Bill Gates, Bill Clinton. He's not on the public payroll anymore. There are lots of people who wield enormous power and influence in our society who are not public officials. What do we do about them? Well, the court decided in the Butts case and the Walker case in 1967 that public figures will be treated exactly the same as public officials for constitutional purposes. They'll have the same burden of proof. They have to prove actual malice just like public officials. And then the next question is, what about private figures? Huh? What the court said in the Butts and Walker cases is that public figures are people who occupy a position of power and influence and who have ready access to the media to correct or counteract statements about them. So you look at, this is somebody who makes a difference, and somebody who, if they announce a press conference, reporters show up, and what they have to say is reported. They have both power and access to the media, and people who meet those requirements will be considered public figures. They get more specific in the Gertz case, which we'll get to in just a little bit. Mark? Yeah, you would think that would have some effect because of your ability, if you're the one who's been trashed, to reply almost instantly to the very same audience that heard the libel in the first place. The courts, as far as I'm aware, have not made anything of that fact. Nor have they made anything of the fact that there's all this internet speech that's different in any way. The same libel rules apply to the internet as apply to any other medium. Okay,
so the case established that public officials and figures have to prove actual malice. But if the court had been on the consumer line, would it have made something of the fact that, as Sullivan kind of pointed out, that the New York Times had to release the fact-check statements in the ad and argue that the New York Times taking these statements weren't accurate?
Yeah, well, that has to do with how you prove actual malice. And that was not considered in Sullivan or immediately or in the public figure cases, but it was considered in Gertz and in subsequent cases, which we'll get to soon, either today or Thursday. But just to where we are here in the Sullivan venture is that in addition to the common law element, wherever you happen to be, in order for a public official or a public figure to win a libel case, he or she has to prove actual malice, focusing on the defendant's state of mind about the truth, not about whether the defendant hated you or acted with ill will or anything like that. Pause here for a second. How would Sullivan have been decided in 1864 rather than 1964? Who wins? Who? Sullivan wins his case? Who said that? Aaron? Sullivan wins his case because? No, not in 1864. In 1864, truth was well established as a defense. I can't pinpoint the year, but it was somewhere between 1735 in the John Peter Zenger trial and the middle of the 19th century when it was acknowledged everywhere that truth was a defense. And some states may have fallen in line quicker than others. This wasn't a constitutional decision, it was just in the evolution of common law rules. See it? Wasn't it right? Would be considered seditious in 1864? Well, you might come trippingly off the tongue, well, that's seditious, but would it have been seditious libel? Prosecutable? No. Libel in government had never been recognized in America since the First Amendment was adopted. Robert? Possibly, depending on whether the state insisted that the statement be true in every particular. And I think the Alabama court came close to that. Some states said it need only be substantially true, rather than every part, every comma in the thing has to be true. I don't know. No, it's an easier answer than that. I mean, Sullivan has to win his case in 1864 because there's no First Amendment applicable to Alabama. If he meets his common law requirements, that's the end of the case. The 14th Amendment due process clause hadn't been adopted yet. It was adopted in 1868. That's what applied the First Amendment rules to the states. So just like in Stromberg's situation, just like in Neer's situation, the bad guys would have won all those cases 100 years before because the 14th Amendment wasn't in effect. Well, what alternatives might the court have used to accomplish its purpose? As I said, the court's logic didn't lead inexorably to the actual malice remedy. It looked like it was going to lead to the abolition of libel suits by public officials. And that would have been an option, and that option was one that was much to be preferred by Justice Hugo Black, who files a concurring opinion with William Douglas, both First Amendment absolutists, and they want the court to say that there can be no liability for criticism of a public official and how he or she performs his public duty, saying that evaluation of the speaker's state of mind is an evanescent protection for speech. Poof, it's gone up into the air. It's evanescence, not a real protection for state of mind. Black points out that which he knew well. There's not any doubt that this jury would have come out exactly the same way had they been instructed, oh, you've got to find actual malice here. They would have decided the case the same way. And I have to say that this whole evaluation of the publisher or the speaker's state of mind required by the actual malice rule, admittedly, it is a significant protection for speech, no doubt about that. But it is a costly one, because if the issue is, did you know it was false, did you act recklessly with regard to truth or falsity, that empowers the plaintiff's lawyer, the defamed person's lawyer to rummage around in the newsroom, to rummage around in your mind, to find out what you knew and when you knew it, in order to be able to prove that you knew it was false or that you acted recklessly. So who did you interview? Who did you? They take your deposition, swear under oath, tell the truth. You're the reporter, and they rake you over the coals. Every single word you write in this story, the drafts of the story, the memorandum that you send to the editor about what are we going to do with this, the marginal note that the editor writes back, let's get the son of a bitch. You know, all of this will relate to the state of mind of the publisher, and all of that is invited. This excruciating process of dissecting how the story was put together, all of that is attributable to the actual malice rule. So it's you know, the press certainly would have been better protected had the court gone all the way and said no libel suits by public officials. That would allow liability for suits about the private conduct, even of public officials. Why didn't the court go there? Why do you think Justice Brennan was unwilling to go the distance and say public officials can't bring libel suits about their official conduct? All that reasoning is out there. Take that last step. Why would he hesitate? Why do you think? Tina?
So for us, people saying false things just because they can. I guess that's the only logical thing that is here, is kind of saturating or invigorated love.
Well, we got a clue sometime after Sullivan, when Brennan went up to Harvard and made a speech, which was then published. And it seemed that what bothered him was that if they abolished libel suits by public officials, that would permit deliberate lies. That deliberate lies about a public official could be made with impunity, with no consequences. And Brennan and the court majority of 6 refused to go that far. Justice Goldberg agreed with Black that they should go ahead and go all the way and abolish libel suits by public officials, allowing suits related to the private conduct. And he recognized that it won't be easy in every case to distinguish what's an official's private conduct from what his or her public conduct is. But he said that's not nearly as difficult a determination to make as deciding what was in somebody's mind when they published this whole actual malice idea. And that he turned the court's reasoning on the libel and government point back on the court. He said, the court says can't have libel and government, and this whole idea that libel, criticism of a public agency is criticism of the official charge. Alabama had it right. That's the way people look at it, Goldberg says. And therefore, you ought to abolish libel on public officials as well, because the agency and the head of the agency are interchangeable in public mind, and you should go the whole way. But they say the court was unwilling to go that way. Subsequent to Sullivan, the court has considered whether they flirted with the idea, whether the important factor ought to be the content of what's said. Is it a matter of public concern, which would trigger the actual malice requirement? And the court rejected that notion and stuck with the idea that it is rather the status of the plaintiff, public or private, that dictates whether the actual malice rule applies. And the court has also considered, or at least a couple of justices did, whether the solution should have been simply to limit the damages that are available to a public official or a public figure to actual out-of-pocket provable damages. Because in most cases there aren't any. You know, there aren't hospital bills, psychiatrist bills, lost income, and so on. Rather, it's the insult, it's the hurt feelings, it's the generalized impaired reputation that is being complained about. And if you required them to prove actual damages, there wouldn't be the lawsuits. But the court has rejected all that. The Sullivan rule lives, thrives, is still the law. We have to fill in one of the blanks, a couple of the blanks, with the Gertz decision decided 10 years later, 1974. And we'll do that on Thursday, when we'll also consider false speech in the Alvarez case.